Hi, I'm Emily Reed. I worked at the Washington County District Attorney's Office in the Juvenile Department. The first thing to understand the position is to know how juvenile law works. So it's separated into delinquency and dependency. And delinquency is your typical criminal cases, just like you would see in adult courts, but it's children. And dependency is kids that the state has sued for custody of the children from the parents because they've been deemed unsafe or an immediate threat of harm. So one of our main roles is to go to shelter care hearings. Those are statutorily mandated hearings that are 24 hours after a child has been removed from a home, and they just establish probable cause of an immediate threat of harm. So at those meetings, the mother has their own attorney, the father has their own attorney, and the children have their own attorney. The children can have the same attorney if they have the same interests, if they all want to stay with mom or dad or whatever it may be, or don't want to stay in the home. But the children can have different attorneys if they have different interests. Say one child wants to stay with the mother and one child wants to stay with the father. So at those hearings, each person gives their statement. Usually the mothers and fathers deny the allegations. Children's attorney, DHS, and the state, which I would represent, all typically have the same interests at that point. Largely, a lot of the times, is to get the child out of the home or to have a 24-hour safety service provider, so someone that stays in the house with the parents with the children at all times to monitor what's happening. Occasionally, though, because DHS does have a duty to try to keep the child in the home with whatever sources they have, if that's a valid option and it can be safe for the child. So sometimes DHS will recommend that the child stay in the home with a safety service provider when the state or the child's attorney may argue or put forth that the child should be out of the home. So those are every day if a child has been taken, depending on that. And they're in the afternoon, so it's an afternoon court appearance, and they're usually pretty short unless it's some large circumstances or something they weren't expecting. Other than that, we follow our cases. So for dependency, we have a status conference, which is kind of like a case management conference in criminal law, where you meet with the attorneys and the child's attorneys. You get an update on how the child's doing and how the current safety plan is working, and the parents' positions, if they're doing anything, like if one of the allegations is drug treatment, if they're seeking treatment, or any kind of admissions they are willing to make or language changes at that point. So sometimes the case will resolve at that point, but usually what happens is you go at least to the court date, and you can, in dependency, you can settle at any point in the case. So oftentimes you'll meet for trial, you'll have everything ready, and it'll settle that morning because of sometimes the parents just need the pressure or the arguments they thought they were going to work, whatever the reason may be, they oftentimes settle on their court date. But if not, you go through with a dependency trial. I unfortunately have not yet been able to do one of those trials because all of my cases have settled. But when those go forward, it's a little bit different. You still do the opening and the state still does go first, but followed by that is dad's case, mom's case, and the child's attorney. So everyone gets a chance to speak, and every witness you call is crossed by all of those attorneys. Again, sometimes the child's attorney won't cross a witness that you've already directed because your positions are aligned, but if not, or if they want to elicit something that they thought you missed, that they might jump in that way. I did have one delinquency trial, which was a really, really good experience, particularly meeting with victims and the witnesses beforehand, learning how to prep witnesses and victims for trial and how to ask sensitive questions and still elicit the answers you need. Particularly because every party in the case is a child, so you have to be very cognizant of that when you're working these cases. After that, I did get to meet with my supervisors and get feedback, and I was able to meet with the judge after and get his feedback on what he thought, which was really, really helpful. I learned a lot in this position. It's really fast-paced. You learn a lot quickly and learn a lot about how to manage meeting with other attorneys and DHS workers and a lot of different people and personalities. For the specific position, Washington County is a little bit more conservative. It has a more justice-oriented or penalizing view of justice. So I don't think it would be a position for everyone, but they do have really hardworking employees. They are very respectful, and a little bit harder in the juvenile department because everyone's so busy, but everyone really does try to make themselves available for questions. So I would recommend it to anyone who's really self-confident and can do well under not having a ton of time with their supervisor in the juvenile department. It's a lot of great experiences and a lot of court time.